And of course, in studio, we want to begin our conversation this morning as we paint the picture of the road to the 2022 general election. What is being done? What are stakeholders doing? What is it that we are doing as the country's preparedness for the general election? And today we are taking this to the Political Parties Dispute Tribunal to look at the state of their preparedness. And I'm having the chairperson with me in studio, Miss Desma Nungo. Thank you for creating time for us.
Good morning. Thank you for having us.
All right. We're just coming from that session by IEBC this morning. IEBC summoned Muranga woman representative, Honorable Sabina Chege, concerning what she said when it comes to claims of voter rigging in the August polls. Your quick comments about not specifically, the session that is currently going on, because it is still, generally the role of these political players and the magnitude and the power that comes with their remarks and even their actions in terms of how it influences the electorate to behave or decide, make certain decisions.
I think being an electioneering year, the environment is fluid. So what I would say is that as leaders or even as Kenyans, we've got to be cautious about the statements that we make, because the public is listening to us, and sometimes the public is influenced a lot by what their leaders speak to. So it's important that we exercise a lot of caution, exercise restraint where we can, and where we have issues that we need addressed, there are appropriate mechanisms for bringing them forth with a view to having them considered. So that's what I would say. But as you note, the matter is currently under the IEBC's determination. We will wait to hear what the determination will be. Yes.
All right. Of course, we cannot comment on this particular matter because it is still under investigation. Right. But I just want you to talk to the electorate at this crucial time when their leaders will be, visiting them in different parts of the country, and they'll be talking to them and sending messages. What should the electorate have in mind when it comes to receiving this information? What fundamental principles should guide them in deciding how to act on the information they receive from these leaders?
I think the electorate should just be guided by what you believe is morally right and morally acceptable, and what would be the principles of what we consider to be natural justice, the norms in the society. So even as we listen in, because of course we are going to hear a lot of things coming out, the mood is already out there, we are able to sieve and know this is good for us, this is not good for us, this is the truth, and this is not the truth. So I think let us just exercise our minds. Each and every individual human being, within you have the inherent capacity to know and ascertain what is right and what is not right. So let's just have that reason within us prevail, even as we consider what is being put out to us.
All right. Thank you for that. And now I'll take you to what you do best.
Yes.
Let's leave that to NCIC.
Correct.
And managing hate speech and that. Let me take you to what you do best. The Political Parties Dispute Tribunal. You chair that particular tribunal. As we begin this conversation this morning, many would want to know what is the mandate of the Political Parties Dispute Tribunal.
Okay. So the Political Parties Dispute Tribunal is a quasi-judicial. When I say quasi-judicial, I mean it's a body that exercises judicial functions, but then not strictly speaking a judicial entity. So it's a quasi-judicial entity that hears and determines disputes arising out of political party affairs. So you note that political parties, they undertake a lot of processes, and out of these processes there are bound to be disputes in one way or another. So in the event of such disputes, the law allows them first to resolve them internally, and then once they have attempted to resolve internally and there's still dissatisfaction, then they're able to present their complaints at the Political Parties Disputes Tribunal. Now, to break it down, when I say disputes involving party processes, it could be a dispute between a member and a political party with respect, for example, to how their constitution is being interpreted in relation to a particular incident. So they can be able then to come before the PPDT once they have attempted to resolve it within their party. It could be a dispute between political parties. It could be dispute amongst coalition partners, and then it could also be an appeal from the decisions of the registrar of political parties. So we hear both the complaints and then we also have the appeal avenue also. But this is from the decisions of the registrar of political parties. And to add,
for example, if the registrar of political parties bars a candidate from vying in a particular election, that candidate can present that particular case?
Yes, in the process
to the tribunal?
Indeed, the registrar of political parties is the overall regulator of political parties, and they make decisions in one way or another that concern the party. For example, or even so for example, if a party wants to change its particulars, and then for one reason or another the registrar is not satisfied and declines to make that change, for example in its officials, because they are not able to see the minutes that gave rise to those changes, and then so the registrar declines. So then an aggrieved party can move the tribunal by way of an appeal, asking that the tribunal looks into that particular matter. So it varies from one exercise of jurisdiction to the other of the registrar.
All right.
Yes.
There's a bit of confusion, and I want you to clarify. What's the difference between your mandate as the Political Parties Dispute Tribunal and the mandate of the IEBC's Dispute Resolution Committee? And also we've seen such cases being taken to court.
Correct.
So who does what? What sets the boundary?
Okay. To start us off, we need to be clear that the IEBC, pursuant to the Constitution and the IEBC Act, they have the mandate to hear disputes arising out of nominations. Similarly, the Political Parties Disputes Tribunal, pursuant to the Political Parties Act, are also clothed with this mandate of hearing disputes arising out of party nominations. So in essence, there is concurrent jurisdiction between these two bodies in the hearing and determination of such disputes. So what normally happens before I get to the court, because the court will be exercising an appellate level, which I will come to. So what normally happens is that based on our experiences in the past, the period prior to 2013, and the public or even our users knowing too well that both of these institutions had this concurrent mandate, there was a bit of confusion because a litigant or a party would go to the IEBC with their dispute, come to the Political Parties Disputes Tribunal, which we normally call the PPDT, with their disputes. So sometimes we ended up having similar disputes before these separate entities, and what was most challenging is that they would also come up with conflicting determinations. So you can imagine this impacted on justice, because at the end of the day you want an order that is clear, that is implementable. So what happened in 2017 is the IEBC and PPDT entered into an administrative arrangement by way of a memorandum of understanding, which we normally refer to as the MOU, where now we tried to give information to the public insofar as which disputes would IEBC deal with and which ones would PPDT deal with. Of course, I've given the historical basis for this MOU, and also just to mention that as two institutions, we deemed it responsible because we are all funded by the taxpayers' money. So we need to work in a very organized way, even as we wait for, because the only cure to this particular situation would be a constitutional amendment.
Well, I was about to ask you, that arrangement, was it enshrined in law? It was, something that you came up with just to manage the challenges that the two institutions were facing with regards to the kind of disputes you were receiving at that time?
This arrangement, we came up with it to manage. Yeah, because as I've stated, both entities' mandate is already enshrined in law within statutes, and the cleaner way of handling it would have been to deal with the constitutional amendments in terms of, because the cry has been, we need to take away dispute resolution out of the IEBC. They already have a heavy mandate that they are exercising in terms of electoral processes. But because the law exists as it is right now, so we worked out a way in which we would prudently manage resources and give space for each of the institutions to perform their functions.
So currently, what does your tribunal handle, and what is left for IEBC to handle?
Okay, so what we will be farming up, we already have an MOU draft for 2022, which picks from the lessons learned in 2017 and tries to improve on them. And in essence, disputes relating to party processes, because you remember I said for us, our concern is to hear disputes arising out of party processes. So if it is a dispute relating to a party process, for example, how a political party conducted its nominations, that would squarely come before the Political Parties Disputes Tribunal. Disputes relating to, for example, registration of candidates, you know, that's a mandate for the IEBC, qualifications, such kinds of disputes then would be referred to the IEBC. So anything outside the party processes would go to the IEBC. But for anything within the party processes, whether it's their nominations, anything they conducted internally.
If somebody enters a coalition on behalf of the party without following due process, that is something you'd handle?
Yes, disputes arising out of coalition arrangements would be within the jurisdiction of the PPDT. Yes.
All right. And I like the simplicity that you have this morning, making it simple for viewers to understand, because it's all about knowing. Because this time around, we're operating in a very different environment. We have a history nominations in this country, some that have not gone very well. This time around, it is even going to be different, because we have the amendments to the Political Parties Act that provides room for joint nominations. How that is going to work out is another big question, you know. We will want to know how you're prepared for that as well. But before I get to that point, I just want to know about your structure as a tribunal. How many members? Is it a full-time tribunal? How do you operate?
Okay. So the tribunal's current composition, and I state current because there are amendments that we'll be discussing soon that expands the structure. But currently, as we sit, we have 7 members. 7 members would be the chairperson, and then we would have 4 advocates, and then 3 advocates and 3 non-lawyers. So it's a mix of skills, combining lawyers and non-lawyers, because it's a specialized tribunal, so we don't need only the lawyers on board, but also we need the experience and the expertise from other fields. So the tribunal sits currently centrally, headquarters is in Nairobi, at Milimani Law Courts, but we'll be discussing the evolution or decentralization strategies that have been put in place. So the quorum for a sitting of the tribunal is a minimum of 3. So out of the 7, then that tells you clearly that we can only have 2 panels running at any one given time. Yeah, so that's how we moved in 2017. So we've got a secretariat at the Milimani Law Courts, a very vibrant team, and then we have a CEO who is in charge of the secretariat. So basically that's our structure. We've got a strategic plan that we're running with. We're also working under the judiciary and together with the judiciary committee on elections, on matters preparedness, and we also have performance measurement understanding that we signed the PMMU contracts with the judiciary.
All right, thank you for that.
On our performance.
So how has your working environment changed courtesy of the amendments to the Political Parties Act? Has anything changed, or the structure and the operations of the tribunal remain the same?
Okay. Courtesy of the amendments, the structure has been expanded because one of the key things that the amendments come up with is the introduction of 18 ad hoc members. Ad hoc members meaning members who would be serving the tribunal temporarily for a period of 1 year, and this is to support the tribunal during this season. You know, it's the busiest season for the tribunal in light of preparedness towards elections. So the 18 ad hoc members, together with the ones that we already have, and noting that the quorum is 3, it means that now we can have a maximum of 8 panels in place at any one given time. So it means that then we've spread our wings, we've spread our branches, and we're able to hear more people, we're able to diversify, we're able to devolve. So that has expanded. Okay. So that's one. The other impact on our amendment is that of the amendments on the PPDT is that it strengthened the enforcement capacity of the tribunal. What the amendments introduce or state is that currently we are able to punish for contempt. Should anybody act in contempt of the tribunal orders, the law has granted us that power, and that power is the one similar to what the High Court does. Yeah, so it's meant to at least give integrity and probity to the processes of the tribunal, to give confidence to the public that if you come before the tribunal and you have a determination in your favor, then you should expect implementation. Right. And if there's no implementation, then there are also consequences to that. There are other few that come up, but I guess we will discuss them as we go along. All right. Yeah.
All right. Yeah. This must be one of the busiest seasons for you as a tribunal. According to IEBC timelines, political party primaries are slated to be conducted between April 16th and April 22nd. So this season around April, March is going to be a very busy season for you as a tribunal. Yes. I just want you to talk to us about some of the measures you've put in place. Are you ready? For this particular journey? And also, as you do that, we are looking at a very different nomination that we have not had in our country, courtesy of the amendments. There's going to be room for joint nominations, basing on the history of nominations in our country and how chaotic some of them have been. Are we ready to manage a joint nomination at this particular time?
Okay, first and foremost, allow me to clarify this. It is true the IEBC has come up with a calendar with timelines, but the dates over there are basically just the deadlines. Political parties are free to conduct their primaries, even as at now. But then again, we appreciate the reality is that they normally move in and do it towards the end of the deadline. Having said that, at the PPDT, yes, we are prepared for the 2022 pre-electoral dispute cycle. And our preparation started way back after the 2017, because what happens is that after 2017, you conduct an audit, you assess your operations, what went on well, what did not go on well, where do you need to improve on. So we've developed knowledge products out of this particular assessment. We had some reports that were coming up. We had stakeholders giving their feedback on our performance. And out of these knowledge products, we have a case digest, we have a 2017 pre-EDR report, we have stakeholders perception report. The common thread running within these documents, which are available in our website, are the areas we need to focus on for 2022, and this therefore has informed our preparedness for 2022. So one of the ones that were coming up were access to justice. In 2017, we were centrally located in Nairobi because we could only have 2 panels sitting. So it means that Kenyans had to come from all regions, all the way from their respective places to Nairobi. This impacted negatively on the right of the public to access to justice. Not everyone is able to afford transportation to Nairobi.
And even the time.
The time might not allow. We've got persons who are abled differently, who are inconvenienced by way of that particular process. So we took it upon ourselves, and what we are moving in this 2022 is that we are happy to state that we are now decentralizing our services, and gladly it's coming at a point that even our capacity has been enhanced by way of the 18 members that we are expecting to come. So what will happen is that we will not just be centrally located in Nairobi. We will be in many other regions, if I could mention a few. So we will be present in Mombasa, we will be present in Eldoret, we will be present in Kisumu, we will be present in Kakamega, we will be present in Nyeri, and we will be present in Meru. Yes. So these regions have been informed by the dynamics, and PPDT takes very seriously pre-electoral dispute resolution, because you may appreciate that nominations in certain regions are as good as an election. So normally it's very, very emotive, and we know the significance of handling disputes really efficiently and effectively at this stage. It helps in quelling at least the temperatures around, and just managing the situation.
And even the post-election,
yes, correct.
Disputes. If it is managed well before the election, then we get less disputes after the election.
Indeed. And a typical example, you remember the 2007, so much happened to the negative because there were no structures that were there in place for pre-election. So access to justice, we have decentralized in the regions that I have mentioned. We have sub-registries with our contact people will be available. So you don't have to come all the way to Nairobi for our services. You will get support from those centers. We'll also be leveraging on technology. Nowadays, there is virtual courts. So you can actually even conduct a court proceeding from your house, from whichever place of convenience that you have. So we'll be leveraging on that also to also just enhance that decentralization.
Ms. Nungo, ideally, how long does it take, and what is the procedure in case a member of a political party or a member of a coalition feels aggrieved by a certain decision or something, and they want to present a case to petition that? What's the process, and how long does it take?
Okay. So once you're aggrieved by a political party's process, rule number one, explore the internal mechanisms. Because if you don't, and you come directly to the PPDT, we will not have jurisdiction. And that is what the law says. So attempt the resolution mechanisms within the party. Each political party has its own constitution prescribing the timelines within which they resolve their disputes. Now, once you've exhausted that, and of course when I say that, I exclude appeals, because appeals, there is no internal mechanism. They can come directly to the tribunal. And I also exclude disputes between independent candidates and the parties, because they don't have a common constitution that binds them. So once you come to the tribunal by way of filing a complaint, if it is any of those disputes I've mentioned, or by way of filing an appeal, if it is against the decision of the Registrar of Political Parties. We've simplified our processes such that we have forms to make it easy, because we appreciate that not every Kenyan can afford legal representation. So for the lawyers, they're already trained in this. They can quickly go through the regulations and draft their pleadings. But for the persons who are not legally trained or who don't have legal representation, we have forms, very simplified, in place, just asking you questions and you fill it in. And then most importantly, attach your supporting documents. So of course, if you have to identify yourself with the identity details, you've got to identify who you are complaining against, whether it's the party or your fellow member of the party. And then you've got to state what is the reason for your complaint. For example, if you're saying that nominations were conducted without adhering to the rules that have been put in place, then annex a copy of those rules or the constitution of the party that speaks to that. And yes, annex any documentary evidence that will demonstrate how the process was conducted. And then once you put in all documentation in place, then our internal processes will kick off. Now, on the timelines, you asked how long do we take?
Because we're working with deadlines of IEBC has deadlines, and electoral processes are very.
That's very true.
So how long?
Ideally, we normally have 3 months as granted by statute. I had mentioned our parent act is the Political Parties Act. It's the one that establishes the tribunal. We normally have 3 months within which to hear and determine our disputes. However, during the electioneering period, like the one we are currently approaching or facing, the IEBC is guided by timelines, and as you correctly stated, they have already come up with a timetable with deadlines that are put across. So as a tribunal, in as much as the law grants us 3 months, we don't have that luxury of 3 months, because we have to work and coordinate with other institutions. Remember, at the end of the day, we are all working towards a common goal. So we cannot sit and say that we have 3 months, and yet IEBC is supposed to be submitting, or certain information is supposed to be submitted to IEBC by 22nd of April, and those issues are subjects of disputes. So we normally ensure that we work within the calendar that IEBC provides. In 2017, for example, we had barely 2 weeks to listen to over 550 disputes. So it means that we sat both day and night and in the weekend, because we had to serve the public. And indeed, we did it today.
I want us to finish this conversation, but very quickly, we are going to be having joint nominations.
Yes.
From where you sit, what can you foretell as the scenario we are going to experience? Is it going to be practical for us? Are we ready as a country for that?
I think generally as a country, what we normally say is that we are such that we are resistant to change. But I think it's an opportunity to try, because for joint nominations, it calls for a lot of negotiations. So
But if a single political party cannot agree on their own candidates, how about now bringing in about 3 or 4 political parties to agree on a single candidate? Are we ready for that?
Yes, it's a challenge. It's going to be a major challenge, but that doesn't mean that we should not try it. Because if we're able to negotiate and deal, then it's better. It's much more. But at PPDT, all I can say is that we are prepared, because we know and appreciate the practicalities, the way you're trying to put it. Disputes about to arise out of such processes, and we will be open to consider what is presented before us.
Okay, that's all the time we had for this conversation. Of course, it's a long journey, and hopefully in the near future we'll be picking it up from here. As your final remarks, what can be done to curb or avert electoral disputes so that we don't get to the level of having 500 and what cases again?
Over 500.
Over 500 cases.
And that was just at the PPDT level. Remember, there was also the Dispute Resolution Committee, which had over 300, and the courts. And I forgot to state, because it's a question that you asked, once a party is dissatisfied with our determination, they have a right to appeal to the High Court. So then the judiciary now processes kick in up to the Court of Appeal. Your final words. So my final words is to call on parties generally. At the PPDT, I think we are prepared, not even I think, but I must state that we are ready. We already know the role that is ahead of us in terms of managing pre-electoral disputes, and we have prepared ourselves accordingly. I want to call on the public to be very aware of the internal dispute resolution mechanisms within political parties, because that is the first port of call. I would also call on political parties to make their internal dispute resolution mechanisms vibrant. Disputes that are resolved internally in an efficient and effective way are ordinarily more acceptable. In the event parties are dissatisfied, then we welcome them to the tribunal. We will be available to serve the public, and we assure the entire public that we will be guided by the merits of the matter that is presented before us, and we will take keen interest in dispensing justice to the public.
Thank you so much, Ms. Desma Nungo, an advocate.
Thank you for having us.
Thank you so much. An advocate and the chairperson of the Political Parties Dispute Tribunal, just shedding light on what the tribunal has done in terms of preparedness for handling disputes emanating pre the August polls. Thank you so much for creating time for us this morning.
Thank you for having us.
All right. We're going to be shifting gears in just a bit. We're still on the road to the 2022 general election, so stay with us. When we come back, I'll be engaging leaders who are going to tell us what are some of the issues that ought to shape this coming general election. What should Kenyans focus on? So do stay with us for that and much more coming up after the break.